Friends, we are going to start. Today is the 276th Friday group meeting. The speaker is our beloved lady senior advocate, Ms. Mahalakshmi Pavani ji. The topic is a bird's eye view of my book on women laws from the womb to the tomb, rights and remedies. This was recently released by our B.V. Nagarathna ji and K.V. Vishwanathan ji and Hima Koili ji in IIC. So huge gathering. I too attended, Mahalakshmi ji. This was the book. Before I say few things, Geeta Verma will read Madam's CV.
Thank you, Sir, for giving this opportunity. Honorable seniors and dear esteemed members, I am deeply honored and privileged to address you today and speak about a trailblazer who has championed the growth and dignity, a legal luminary, a powerful voice of gender justice, and an extraordinary advocate, senior advocate, Mahalakshmi Pavani. She is a leading voice in the Supreme Court of India and a tireless advocate for the gender justice. Madam Pavani has carved out a monumental career in Indian law. She holds the distinction of being the first woman from Karnataka and one of the earliest women overall to be designated a senior advocate by the Supreme Court of India in 2015. She began her career in 1992 and later joined the chambers of the legendary late Shri P.P. Rao, where she commenced her distinguished practice at the Supreme Court. Over the decades, her expertise in constitutional law, service law, and criminal law has been represent highly significant and complex matter. Beyond her professional achievements, she has actively engaged with lawmakers and institutions, including being nominated by the Chief Justice of India to the Legal Advisory Committee of the Bar Council of India, and has spoken publicly to reform such uniform divorce law and strengthening access to justice for women. She is serving as President of the Supreme Court Women Lawyers Association and holds advanced legal degrees in human rights, labor and administrative law. Most recently, she authored a wonderful book titled Women Law from Womb to the Tomb, The Rights and Remedies, an exhaustive guide to women's rights and legal remedies in India. Today, she joins us as an author, speaker and editor to discuss her latest work. This comprehensive guide charts a woman's rights and remedies from birth to old age, addressing critical issues like female foeticide, workplace harassment, property rights, domestic violence, and more. This book is poised to be a vital guide for legal professionals, students, and citizens alike. Please join me in giving a warm welcome to Senior Advocate Mahalakshmi Pavani.
Thank you, Geeta. So nicely explained. This is the way we are giving the opportunity to younger generations. Now, again, we are gender today. We are following for vote of thanks also, for CV reading also, speaker also. Total 100% yes.
Thank you very much, Geeta. Learned members of the bar, esteemed colleagues and friends, it is a profound honor to stand before you today and address the Friday group. I congratulate Mr. G.Seshagiri Rao for creating this academic space in the precincts of the Supreme Court, where every practitioner is busy running from one court to the other. The endeavor of Mr. Rao to call lawyers of eminence from to speak on diverse subjects illuminates the younger members to augment their knowledge, and the Friday afternoon is one such time where members are free, hassle-free, and have the time and the capacity to imbibe interesting concepts. See, it was during COVID when the world was facing such a great illness and where I lost my mother to COVID. So it was that time the birth of this book came to my mind. The idea was conceptualized by me because it was at that time I was grieving my mother's loss, and it was very painful, and an idle mind is the devil's workshop. So I wanted to do something, and I wanted to pay a tribute to my mother and a contribution to society, because my mother was a single woman. She was a widow at a young age. She brought up 4 children, so her struggle was very, very difficult. So it was at that time, at that juncture, I thought that I should do something to empower women, to educate women. And my mother was just a school dropout because she got married at the age of 16. And raising 4 children was not easy, given the fact that my father was a very successful industrialist and a businessman and had so much of litigation. So we had company litigation, bank litigation, and tenant and landlord litigation, and she had nobody to guide her. So she was in fact misled and cheated and things like that. So when I looked at her life, her struggle, then I thought, and I also struggled through COVID, I also was on deathbed. So I thought it was my contribution to society, that I should give back to society what I can. So that was how this idea of women's laws came to me. This book, it covers all women's safety, welfare, protection, because, and I also wish we lived in a world where I never had to write this book, because where women were treated with dignity and respect, where their voices were heard and they enjoyed equal opportunities. Unfortunately, that world is still a long way ahead. So it is an endeavor to illuminate that path for every woman, to embolden her, and whether she walks the corridors of power or the dusty streets of my idea was just to simplify the major concepts of law that relate to women. And let me tell you, this is not a commentary for advocates. This is just an exhaustive guide for lay persons, for students, basically just to empower them, to embolden them, to make them aware of their rights and what are their remedies, so that they can also, gather up the guts to face life. And that was how it started. COVID. It started in 2021, but it took me 3.5 years to finish this book, because it required a lot of research, because every day laws keep changing. So I must place on record my gratitude to my daughter in the profession, Sumedha Sen, who helped me with it, my son Aishwarya Bhati, and my staff. So, and also when I went up to Justice Venkatachalaya with this foreword, I requested him to write a foreword. So he said, Mahalakshmi, I will write it for you only on the condition that you give me the manuscript. I will read the manuscript and then I will write. So he took 6 months to read the book, and then he penned it down for me, and he said, it's not merely ink on paper, but passion poured on paper to make it a beacon of awareness. I am eternally grateful to His Lordship M.N. Venkatachalaya, who was 96, who is 98 now, but 96 at that time, for having spent 6 months to write a foreword. So when he penned this, he said, he noted, which is unedifying, he said, we must never forget the notorious English cliché. A woman can never be outlawed because a woman is never in law. Now, and this book has 24 chapters along with the acts, which makes this the 25th. So it covers all topics, right from abortion, female feticide, surrogacy, bride trafficking, maintenance, dowry, divorce, prostitution, sexual assault, harassment at the workplace, and it covers everything. So that's why from all laws, from life, from birth to death. So that's why I put it as womb to the tomb. So, and the book also recalls Justice M.N. Venkatachalaya recalls the first English case of Myra Bradwell in the US Supreme Court in 1873, wherein this English lady who was very qualified and very rich, they denied her the right to practice law based on her sex. And they declared that the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it many for the occupations of civil life, and confined her to the domestic sphere as her paramount destiny and mission. Although she never practiced law, she was later admitted to the bar of Illinois in 1890 and the Supreme Court of the United States in 1892. So in India, Regina Guha mirrored that struggle. In 1969, her application to enroll as a pleader of the Alipur Court, District Court, was denied by the Calcutta Court by a bench of 5 judges. Thereafter, Subranshu Bala Hazra, she also was denied the right to practice law by the Patna High Court. So these women were noticed by then, and then the Legal Practitioners Women's Act of 1923 came into force, and it was Cornelia Sorabji who became the first woman advocate to be enrolled in the UP state, and she was the first woman to have her graduation from Oxford, first woman to have her LLB from Bombay, and she practiced. So that is the essence of our constitutional journey, which has been a constant struggle to cast off gross stereotyped distinctions between the sexes and move towards true equality. We also have to remember that rampant subjugation is practiced, perpetuated and justified in the name of custom, religion, social order, harmony, protection of the institution of marriage, and ironically, under the charade of a woman's own interests, the deep-rooted parochial attributes of patriarchy, preference for sons, polygamy, dowry, creation of a regressive environment, and social order of dependency shattered a woman's self-esteem to such an extent that she has genuine doubts as to her worth and her value and efficacy, besides homemaking and childbearing and child rearing. It's been a constant struggle for women right from 101 years till today. We are still struggling. We still struggle to find a foothold. Here also in the Supreme Court, you think women are taken seriously? No, we are taken very lightly. We still have to struggle. You think any of us think that women are paid equally as the male seniors? No, it's still a struggle. Every day I have to struggle to make myself heard. So every day I have to prove my mettle, I have to prove myself. So, and I would also like to quote David Michel, our lives are not our own, from womb to tomb, we are bound to others, past and present, by each crime and every kindness we birth our futures. But having said that, let me tell you one more thing. Women don't support women. It is men like him who support women. Remember that. Because of your support, we have come this far. Everywhere it's a patriarchal society, but men also support women. I would like to say that. So since time immemorial, women not only in India but across the globe have been subjugated. So it's just not in India, it's across the globe, whether it's America, Iran, China, Japan, Korea, everywhere. But in 1947, we got our independence, and then the Constitution of India, which was a transformative and a gender-just document, came into existence as the basic law of the land. So we had 299 people who were members of the Constituent Assembly, out of which 15 were women. But when the Constituent Assembly, the document came into force on the midnight of 26th January 1950, there were only 284 signatories. Now, it is only because of those 15 women there, we came to have 3 wonderful gender-just kind of a document. And there with 3 or 4 articles which I would like to say. One is Article 14, which guarantees equality before the law and equal protection of law, and prohibits the state from discrimination on grounds of religion, race, caste, sex or birthplace. When you have Article 15, again reiterated prohibition on the same grounds and empowered the state under 15(3) to make special provision for men and for women and children. Then you have Article 16, which was slightly different, wider, but it confined to employment, and outlaws any other discrimination with respect to employment on the same grounds. Then you have Article 21, which ensure that all citizens right to life with dignity, right to life with dignity, right to live, to have a safe professional environment, and so many other rights. So, although the Constitution ensured all these rights for women, it has been a long struggle for women. One of the earliest cases was in 1965, where the Bombay Labour Union versus International Franchise Private Limited was there, and the Apex Court struck down this unconstitutional rule of the company, which stated that if a woman gets married, her services would be automatically terminated. Excuse me. So, right from 1965, although the Constitution guaranteed all that, there were laws which were going against us. So then you have the C.P. Muttama versus Union of India in 79, which also proved that coveted civil services was not from misogynistic orthodoxy. She was a civil servant, but qualified civil servant and the first Indian woman ambassador, but who was overlooked for promotion, and then she also had to move the Supreme Court. Then you have the landmark case of Nargesh Mirza in 1981, where discriminatory rules and policies of Air India based on gender norms were challenged. Then you have Mary Roy versus State of Kerala, which was argued by our very Indra Jai Singh ma'am, where the petitioner was a Christian woman, and after her parents' death, she had to fight her brother, and she challenged the discriminatory stand of the Travancore Christian Succession Act of 1902. So, and that prevented women, Christian women, from having equal share in their family property, and that again was struck down. So then in 2007 you have Anuj Garg versus Association of India, wherein the Supreme Court also struck down a rule that prohibited any woman, banned the employment of men under 25 and any woman from in part of the premises where intoxicating liquor was served. So the court ruled that this blanket ban was violative of Articles 14, 15, 19, and it was a form of a gender discrimination. Then you have the famous Babita Punya's case in 2019, where it held that all women officers were eligible for permanent commission, giving them commanding positions. Then you have the Municipal Corporation of Delhi's case versus female workers in 2000. I am saying this because of late there was a similar incident which has now been challenged by the Supreme Court Bar Association. So in this case, the Honorable Supreme Court ensured that a woman employee in advanced stage of pregnancy cannot be compelled to undertake hard labor, and the court emphasized that this was detrimental to the women's health and the fetus of the child. And in So Mittal's case versus Karnataka, this was about a woman who was working night shift and she got into a taxi while going back home. She was raped and murdered. So then the court ensured that the criminal liability will be placed on the employer. So the management of the company will be held accountable, and the night shifts were then regulated, so making it safer for women. So then we have, so because I have a large topic and it's a large thing, and because of time constraint, because we are having the Chief Justice's farewell, and so I will be just restricting myself to about 4 or 5 topics in short. So the first one I would like to focus on is sexual harassment at the workplace. So the fight for equality takes place not in parliament alone or courts, but in every public space. So back in 1991, Neera Mathur versus Life Insurance Corporation, this honorable court saved women from considerable embarrassment and humiliation by striking down the rule to furnish intimate details about how many children they were having, when did they have their last period, and information regarding their conception, and which was violation on their right to privacy. And this court recognized that the woman employee has her right to her privacy. Of late, Maharshi Dayanand University, they asked the women to submit proof of their pad, menstruating women to show their pad to say they were really menstruating. That was very, very disgusting, and it was offending the any woman's dignity. And at this time and stage of life, we are in the 2025, and to ask for such a thing, sanitation workers, they were supposed to submit, it was pathetic of them. So I think the Supreme Court Bar Association has moved a petition. I think it's in the pipeline. So but it was the sexual, after 91, this 97, where we come across Vikchaka, who was a social worker and who was working as an Anganwadi worker in the state of Rajasthan, where she had to prevent child marriages from happening. So she prevented a 1-year-old child from getting married, a 1-year-old baby. So when she was prevented, the higher community people, they didn't like this. They took it as an offense. They took it as their honor, upon their honor, saying, who the hell is she to prevent us from allowing our child to get married? And they ensured she was gang raped. So that time she lost, but there was a women's organization called Vishaka which moved the Supreme Court, and that is how the Sexual Harassment of Women at Workplace Prevention, Redressal and Prohibition Act had 2013 had come to this. But I will tell you, because I have studied this, and please remember, Vishaka was delivered on 13th August 1997. And does it take 16 years for a direction of the Supreme Court to turn into an act in 2013? So it was the horrific gang rape of Nirbhaya on December, which happened, where the country went, they cried and they went on strike, and they said, we will not tolerate this. Women are being raped, gang raped, brutally murdered, and especially the insertion of that iron rod was the point of torment which has hurt every man, every woman, every living being across the length and breadth of this country, which led to the anti-rape laws, which led to a commission led by Justice Verma and former Chief Justice of India, Justice Leela Seth and Gopal Subramaniam. And that is how the 2013, April 21st, the Posh Act came into place. So that was a path-breaking verdict, and it may have been, it cannot even be said to be a direct legislative growth from Vishaka to section 2013 Posh Act, because 16 long years is a long time, and unfortunately in our country people wake up only when there is a crisis, otherwise they take things for granted. So this definition is an aggrieved woman, and an aggrieved woman is subjected to harassment in relation to her workplace. It covers all professions, it covers all professions, and the definition of sexual harassment includes to prevent a creation of an intimidating, offensive or hostile working environment. So, and this is a social legislation. This is a social legislation which has a redressal mechanism for women. Why? Because women, they have to choose between their dignity and employment. So they said it is their right to life, it is their right to serve with dignity, their right to life, to protection, to a safe and secure environment. So it is a fundamental right. So today I had the occasion to appear in a matter where the Bombay High Court had said that a woman, an advocate, does not come within the definition of Posh under the Bar Council. So Posh cannot be applied to Bar Council of Maharashtra and Goa, wherein their lordships are pleased to issue notice today, because the Bombay High Court went on an erroneous fact. They read, the focus was their ruling was in a very narrow and rigid and very literal depiction of this Posh Act, because they relied, saying that in a Posh Act it's only an employer and employee relationship should exist. So they took it in the literal construction, and then they said no, we have the Advocates Act, section 35 is there. So 35 deals with professional misconduct and other conduct, but it nowhere defines what is other conduct. It does not stipulate sexual conduct. And I will say that it's more important because Posh Act under section 16 gives confidentiality. So when you report a sexual crime or a sexual kind of abuse against yourself, or you go and it is completely safe. The confidentiality clause is maintained. Dissemination is not allowed. It cannot be published. So you are safe, and the accused also is safe. So but whereas in the Advocates Act, it comes within the purview of Right to Information Act. But this act does not come under the Right to Information Act, and it's a very, very confidential thing. So that is the plus point of this act. So and the court was very gracious enough to accept my pleading, and then they issued notice. So and it also expands the definition of an aggrieved woman. It does not say that Posh, I'm talking about Posh, so 2F, it does not say that one should be within the an employee. It covers women who are law researchers, interns, typists, agents, anyone, even a client. So basically it wants to protect women at the workplace. Then we also have this MJ Akbar case, that Me2 movement, and that case was a stark reminder to see how pervasive the workplace harassment can be at the highest levels. I'm not talking about the low levels or anything, highest levels, because this man was a celebrated journalist, and then he became a minister, and he faced multiple sexual allegations of sexual harassment from women, and who courageously spoke out about him. And it was deeply disheartening to see, despite the gravity of complaints, the process was long, arduous, and fraught with public scrutiny for survivors. So the situation exposed the chilling reality that often women face, and the societal and professional pressure when they try to assert their right to a safe workplace. So that, and this also, the law recognizes the reality of modern work. It introduced the concept of an extended workplace, including any place visited by the employee during the course of employment. Even our Supreme Court has this ICC, GSICC, and we have any kind of harassment which happens on the precincts of the Supreme Court, which happens not only between lawyers and between the lawyers themselves. It could happen between a canteen staff or a registry staff, and it applies to the chambers within. So this is a kind of control to curb and make everything safe for women, because women are, forget workplace, women are sometimes not safe in the confines of their home also. So that is also another thing which we have to look at, that is with reference to domestic violence. So so that's how this Posh Act has come into force, and everyone is just trying to help everyone by creating this. And but unfortunately what happens is, sometimes the woman is intimidated, and she feels that kitna time samay chale jayega, kitna lamba der hoga, I mean, the court is very tight pe tarik, and also they don't want to do it. Sometimes they want to do it. So it all depends, but ultimately it is a protection. So my next address will be on dowry. So it is a domestic sphere where the shadow of injustice lengthens for too many women. And the scourge of dowry and the grievous phenomenon of dowry deaths is a painful proxy for the failure to prevent domestic violence. So the origins of dowry were very noble. It was to provide the girls, their own daughters, with a form of a pre-mortem inheritance, and because that time was a time when all the properties went exclusively to the son. So even in times when sometimes the parents would bid the girl by giving her a buffalo or a cow, or something like that, to protect her, to ensure that she's safe, and they give her ornaments because she never had property, or there was no money or no FDs and things like that. So she could rely on her ornaments for her future consumption. So it was a matter of, then slowly dowry started happening. It became for women, they thought it was a matter of right, and then they started demanding. So because they thought their women were incapable of earning, and it was to enable a socio-cultural environment where it was an entitlement of the grooms and families, and if they were not given, they would humiliate the brides and their families. So it was most horrifying. Then what happened, it became a vicious circle. Even after complying with demands, the bride was harassed after marriage, and then slowly they started, they were beaten, tormented, tortured, so they started committing suicides, they were burnt and things like that. So to combat that menace, they brought in the legislation on 26th of December 1983. They passed the 498A. So that was brought in the criminal amendment, criminal law IPC, and that was to combat the growing menace of dowry related violence and to protect women from cruelty and harassment. So that is how this 498A came. And then you had this dowry death also, which was inserted in the IPC 304B. Why this section was actually a safeguard against all those women who were killed and by bodily injuries or burns, and it was basically a safeguard. It was because men were putting so much pressure, they were killing these young girls, innocent girls, under the garb of dowry, and ultimately the legislature had to step in to bring these safeguards to protect these young children. But now if you see 498A is being misused, it is, so that is how it is. But there was this judgment of the in Nathu versus state of UP. The court said dowry death is worse than murder. Why worse than murder? Because it is being committed by the man who married her, who took the saptapadi with her, who held her hand, who promised her security, safety, and ultimately, pushed her towards death. And very recently in Tripur, if you all remember that Kanya's case, wherein a 27-year-old, even after giving a 1 crore rupees Audi car and doing so many sovereigns of gold and having a lavish wedding, she took pesticide and killed herself because her husband and in-laws were torturing her. So it's very unfortunate that even in today's date, when people are educated and things like that, people are given to these kind of situations. So she left her audio message for her father and claimed that her husband and in-laws inflicted tremendous mental and physical torture upon her over dowry. So I personally feel that a woman's own family is as guilty as everyone, because they should have spoken to her. And that, what does it say, that women take this drastic step? Why? Because they don't have anyone to confide in, they don't have anybody to support them, whether they, even if they have parents or siblings or relatives, mostly the parents will say, she has another sister or brother, they'll say adjust and go, why do you want to bring it out, नाम खराब हो जाएगा, नाक कटवा दोगे परिवार के सामने, इज्जत मिट्टी में मिल जाएगा, एडजस्ट कर लो. So, and this is our culture, Indian culture, where girls tie Raksha Bandhan, Rakhi to boys, and men are supposed to protect their sisters, and they pledge to protect her, but there's nobody who protects her. So when she ends up in a greedy and abusive marriage, she has no one to turn to, so death seems better for her. So we also have to, unfortunately when she's alive there's nobody there, but when she dies they all want justice for her. So what is the point of demanding maximum punishment for when you do not take a stand for your daughter or sister when she's alive? So do women need to die in this country to be believed? That is the state of affairs. Then we have domestic violence. So this chapter of my book starts with a quote from Emily Mauritian. She's an author, and she says, Argentine author but lives in the US. So she says, if you want to find your contribution to the world, look at your wounds. When you learn how to heal them, teach others. So this chapter squarely looks at one of the deepest wounds in our society, a wound that not only exists in the public square but behind closed doors. According to the National Crime Records Bureau, a crime is recorded against a woman every 3 minutes, and a rape is reported every 60 minutes. 2 women are raped in our country. And these statistics, what do they represent? They represent decades of trauma inflicted in spaces where women and children should feel safest. It is the home, it is where you are living with your partner, with your spouse who you've accepted, or sometimes if it's the father also who's abusing the daughter, or the mother who's being abused. So whatever it is, through history, marriage has hardly benefited any women. Marriages were supposed to give, and where, in a marriage, it is nothing is expected from a man. It is only a woman. She has to give up her career. She has to give emotional caregiving to children, to the spouse, to the in-laws. She has to do unpaid domestic work, child care, and elderly care for the parents. And moreover, like, marriages have been social contracts basically. So they give away their freedom and for basic dignity and human rights, and in exchange for what? Security, acceptance, companionship, and a more important thing is to be valued. You know what women want? We want to be valued. We don't want anything free, at least for the work that you're doing. Value, at least I have something. If men are so successful in their professional careers, or as advocates, you have such successful men, but do you know why they are successful? Because they do not have to bear the burden of bringing up children, whether the children have gone for tuition, whether there's dal in the house, whether there's gas in the house, whether the servant has come. Nothing. They don't have to take care. It is a given that मेरी बीवी है, मैनेज कर लेगी, मेरी मम्मी है, वो मैनेज कर लेगी. So this is a given. Unfortunately, in our society, it's still, the man doesn't want to shoulder anything. Why? Because he thinks he is the finance giver. He is contributing towards the purse. So he thinks the women have to be subjugated. He does not give a ear to them. It is very unfortunate that it's still happening. So this, so for a very long time, this violence was there in a domestic relationship, which was being considered private. But then the government woke up, the legislature woke up, and in 2005, the nation took a very crucial step in bringing out the Protection of Women from Domestic Violence Act. So that is how this act came into existence. And what does this act do? It not only defined what domestic violence was, it just said it was not only physical abuse, but also verbal and emotional torture, sexual and economic abuse. It was revolutionary because it recognized that financial control or verbal degradation is just as destructive as a physical blow. Yet, despite all these laws, our problems continue at an enormous scale. It was in COVID-19 pandemic, when the lockdown forced everyone to stay at home at all times. That was the time the National Commission of Women reported a 2.5 times increase in domestic violence between February 2020 and May 2020. So there were support organizations receiving more calls in the first 4 phases of lockdown than they had in the previous 10 years. Why? Because each one man was sitting in the house under the locked doors, and he was venting out his frustration. And I'm sure most of y'all would have done it with your sisters or with your parents or something like that. So it is a given. Let us accept the fact that, yeah, we are in that kind of a society where all males think they are 10 steps ahead of a woman and they are more powerful. So, and the constant presence of abusers, coupled with victims' lack of privacy, lack of mobility, inability to access support networks like friends or neighbors, they compounded the severity of the cases, and financial distress, unemployment turned homes into pressure cookers, and the most vulnerable suffered the most. So when we champion these laws, we must also acknowledge the critical and social hurdles that remain. We must confront the problem of the misuse of laws. Vital provisions like 498 addresses cruelty by the husband or his relatives. Judicial observation confirms that exaggerated complaints also are reflected in a large number of cases. Sometimes what happens when a woman wants to take revenge, she uses this. she tries to extort, she tries to arm twist the man. So my suggestion there is, whenever frivolous complaints of these kinds come to the forefront, the courts, I mean the legislation should amend the act and say that these people also need to be punished. Where frivolous complaints have come against men, they should also be punished. They should also be given penalty, or they should be subjected to kind of some imprisonment of 3 months. So that is time when women also realize that everything what they say should not be the gospel, because it takes two to tango. एक हाथ से ताली नहीं बजता है, हमेशा दो हाथ चाहिए. So, and nowadays women are also, they are well read, they have so many reels to follow, they have so many gossip things on your Instagram and things where you get free yarn and things like that, so that they try to take advantage and they try to harass them. So this journey to justice of a woman is often hindered by financial dependence. So although this was brought in for the betterment of women, you all must also think that how can we expect a battered woman with children to leave her shared household and maintain a lifestyle. So the domestic violence was brought in so that she could stake a claim in the shared household, or whether she could be entitled for maintenance, because this act is not as laborious, or you don't have to go to a court and things like that. This can be done with a complaint under this act, and where you have people appointed to take care, and then this matter is solved, and it's faster. The laws are strong, but the real solution lies in our culture shift, in a world which we should implement it at home first. So the implementation starts at the grassroots levels. What do we need? We need periodic monitoring of police stations, we need local non-profits, we need women's self-help, we need one-stop centers, we need counseling sessions. Everybody needs to be counseled, right? From the police need to be counseled, the hospital staff need to be counseled, how to handle cases, how to, because every time you go to write a complaint that the girl is missing, what do they say? कई बार गई होगी, रुक जाओ, यार के साथ चली गई होगी. So they are very insensitive. They, unfortunately, people should learn to be sensitive, and these are places where they are governmental offices. So you cannot take this kind of a thing, make these kind of comments, because at the end of the day it's a mother or a father or a brother complaining. How painful it must be. Because I remember this incident which took place a month ago in my hometown Karnataka, where a college lecturer who was newly married, 26 years old, she was missing. And when they had gone to write a complaint, they said she must have ran away with her paramour. But unfortunately, her body was found floating. She had left a suicide note saying that I am being subjected to dowry, I am subjected to cruelty, I am subjected to touch, I cannot take it. She was an educated professor. A professor means a double graduate with an education degree. So, this is the trend which is happening. So, and we also need education and self-reliance. And when we say education and self-reliance, that again begins at home. Why? Because every mother should treat her children equally. She has to be at paramateria kind. Both have to be treated equally. It's not as if the boy should be given said, "Koi baat nahi bacha, aap jao, you don't have to learn cooking," or the girl should not be, so parity should be maintained. And when the boy cries, the mother will immediately say, "Rona mat, ladki ke jaisa rona mat." So that should go, that thought process should go. Everyone should be treated equally. If a woman is given that strength from that day, I'm probably sure that she will surpass a man. So my, in fact, book, and it examines the impacts of domestic violence on their victims, their children, society at large. So, and domestic violence is a growing menace, and we should stop that together. Then we have the fourth focus is on reproductive autonomy and the right to choose. It's the most fundamental of all rights. What is it? It's a woman's bodily autonomy and the right to choose. The right to choose And the core of the issue of abortion is crystallized in the powerful assertion by Margaret Sanger, and she said, "No woman can call herself free who does not own and control her body. No, until she can choose consciously whether she will or will not be a mother." So the abortion debate is characterized by the global pro-life versus pro-choice, whether it's the right of an unborn fetus or whether it is her right to have a child. So this controversy puts complex predicaments upon women. Why? Because earlier the couple in a couple only a man had a right to say whether she could undergo or not. It was not a woman. But then government, regardless of their structures and political ideologies, they were pondering whether a woman possesses an autonomous right or choice of exercising that right of termination versus the natal rights of an unborn child. So it was considering the bodily autonomy versus the moralistic structures and dictating over her right of choice. And Indian jurisprudence, in fact, is better than the US, and it has adopted a liberal and progressive persona. So the court located the right to abortion as a fundamental and essential right available to women. So this right is recognized as a right to privacy, which itself is a progenitor right to life and personal liberty granted under 21 of the Constitution. We must also remember there are rights of an unborn fetus. An unborn fetus also has a right under the Hindu law. It also has a right to property. But having said that, there's now focus is on the reproductive autonomy of an already living person, and here is a child who has not come onto the earth. So now they are giving importance to that of a breathing woman, and it is described as a Bermuda Triangle of policy, politics, and patriarchy. So no, not every woman is emotionally and physically or economically capable of giving birth and raising a child to adulthood, and so many women do not want it. So they have been given the right to terminate a pregnancy, and she cannot be forced to give birth against her will, especially because law or policies influenced by the personal beliefs or moral considerations deny that right to choose what is best for her own life and body. And in India, female feticides are there, and then unsafe abortions are there. So ultimately, you cannot even decide. Here a male child is more welcome than a female child. So here, even that sex determination is not allowed. It is against the law. So, and when people don't want, they go in for these unsafe abortions, which ultimately result in death. And it accounts to 20% of the maternal deaths in India. So it is the combined duty of the legislature, judiciary, and the medical community to remedy this and regulate the Medical Termination of Pregnancy Act of 1971. And we may not find abortion or reproductive rights or bodily autonomy in the context of in the text of our Indian Constitution. However, the Indian legislature has ensured that the absence does not diminish the value of our rights. Then we talk about adoption, child custody, and guardianship. Here also the primary concern is the welfare of the children, which are deeply intertwined with the lives of women, mothers, guardians, or adoptive mothers. And because today's girls are tomorrow's women, so adoption is also a reflection of our society's most profound challenges and deepest desires. A challenge of an ever-burgeoning population coupled with a heartbreaking desire of childless couples to build a family. So whenever it concerns a child's placement, the best interests of the child are always not only a legal phase, but a moral and material cornerstone of the entire process. And in the face of this systemic inadequacy and rapid rise in child trafficking, our Supreme Court again demonstrated its long arm of justice in Gaurav Jain versus Union of India's case in 1997. So it brought to light the plight of children born to sex workers, and they were destined to follow the path of their mothers. So, but the Supreme Court, in a move which I described incorrectly in law, but correctly in morality and ethics, took on the role of Parliament and they utilized Article 142, and they directed the union and state governments to establish child care development and care centers. So that is how the child development and care centers were born, and they were actually born to rescue, educate and skill the children of these sex workers. So, and the judicial vision was a noble precursor because, and it instilled the Juvenile Justice Act. That's how the Juvenile Justice Act sought the creation of the child welfare committees, and it gave safety and identified a place for children to be brought up in an atmosphere where they were not living in brothels, and here they were giving a wholesome treatment of education, care, love, hygiene. They were being taught and they were being brought up as normal children, and that is very, very important. So in fact, during the COVID-19, it had orphaned many thousands of children, and that is how the 2000 adoption guidelines also came into place, and it ensured that a child is not prematurely orphaned. So when we look into the future, we must also find that reimagine the reintegration of children, because children are our future, they are our future leaders. So they also need to be given, especially the orphans, need to be not misused and pushed into begging or any kind of a sad thing, and they are also being given skills and adoption and a better life. So when it comes to custody and guardianship, we must always remember that this happens when a family is in crisis. So the paramount principle which guides the custody cases is the welfare of the child, which is of paramount consideration. So the Supreme Court has always looked into, because here it becomes an ego battle between a man and a woman where the child is. So here the Supreme Court steps in and they see where the child is better, whether the child is better with the mother or the father, who can give a good support system, who can give a good education, who gives more time, who is more loving, who is more caring. So these are the things that have to be taken into consideration when custody is happening. So there is this landmark ruling of ABC versus State, that was in 2015, where the Supreme Court ruled that an unmarried mother is a child's legal guardian, because from time immemorial it was only the father who was recognized as the legal guardian of the child, and after the father, if the father is not available, it is the mother who steps in. So here they said that the unmarried mother is the child's legal guardian, affirming gender equality and upholding her right to protect her privacy without having to disclose the name of the child's biological father. She didn't want to disclose the name because she was having an affair with him. She didn't want the man's personal relationship with his wife and his children to be disturbed and things like that. So she had, the High Court was not in her favor, and ultimately she came to the Supreme Court. The Supreme Court said they recognized her fears and things like that, and she didn't want to have a negative impact on the child. So that is when the Supreme Court held that she is the guardian. So that was how the Supreme Court always ensures that the welfare of the child is of paramount consideration. So then the last thing I want to talk to you all about today, I'll wind it up. I'll talk to you all sometime later in the future about the uniform divorce, which is a baby of mine, which I want to ensure that it is implemented at some time. I've written to the Parliament, I've written to the Rajya Sabha Law of Commissions and to the thing, and to the President of India and Prime Minister, because I feel that a uniform divorce code is a secular act. There is no sacred or sanctity attached to that secular act, because here there are two people at warring paths who want to separate from their spouses, but given the fact they have a life, they have to lead their future, they forget and they spend the rest of their lives fighting in court. So, and there are differences in the Muslim law and the about and if there is a law which is convenient, a uniform law which says these are the grounds on which a woman can seek divorce and a man can seek divorce, irrespective of their caste or community, it will be very nice. So that is how I want to do that. And So a journey of an Indian woman has been full of challenges, and her refusal to be incapacitated by them is inspirational and laudable, undeterred by her tedious path. Her progress is gradual, but it is promising. So the law, the law, even it's merely ink on paper, we advocates and interpreters must infuse them with passion and conviction that they demand. So let us continue to hold the sincerity of our faith and convictions, ensuring that the remedial measures taken today will have an enduring influence on futures. As lawyers, as officers of the court, let us commit to that India I dream of where a country where every woman walks with her head held high, knowing her worth and value and her rights. And also false complaints need to be nipped at the bud. So I would urge all my dear brothers and sisters, if you all want, please do not entertain or encourage litigants with false complaints for the sake of revenge. Please don't do that. And thank you, Sheshu sir. I am eternally grateful to you for giving me this opportunity. And I hope you all had a nice session. I'm sorry I had to cut it short. Thank you so much.
Thank you very much.
Thank
And
you,
I
sir.
request Ruma Pathak will give it.
I would like to extend my heartfelt gratitude to Seshu sir for giving me this opportunity, and my special thanks to Pavani ma'am for taking out time and delivering her lecture on such a useful topic in which she have covered almost all the issues related to women, and she well described her journey, how she had started, and this book took 2.5 years to complete. 3.5 years to complete. And not only Venkatchalaya's contribution also there. This book have 24 chapters which covers almost all women related issues. For example, if I go for that domestic violence, women's dowry, harassment, sexual harassment, so many etc. And not only the journey of so many advocates, for example, Karnnika Seth, the first woman lawyers, her struggle to join our profession, and ma'am truly discussed the points to prove women's right, and also mentioned about some articles of our constitution, article 14, 15, 15.3, 16, 21, and also mentioned some landmarks, laws and cases related to this book. And thank you so much for giving me all these details, and thank you so much, ma'am.
Welcome, Ruma.
Thank you, Ruma. Just go for cup of tea.
Yes, sir.
Join for-
Definitely.